Hey, good afternoon. My name is Attorney Patrick Korody. I'm a military and criminal defense attorney, Jacksonville, Florida, former Navy judge advocate, currently serving the reserves. And I'm here today because I want to talk to you a little bit about DNA. This is just an introduction to how DNA works in criminal cases. I had a case where I was reviewing DNA this morning. And let's start with the basics. How is DNA evidence used in a criminal trial? And the way DNA evidence is used in a criminal trial, whether it's a firearm charge where they pull DNA off a firearm, or it's a sexual assault where they're pulling DNA off of a swab from a sexual assault kit, the way DNA works, it's the same. The goal of DNA evidence is to show that a suspect's or slash defendant or victim's biological evidence is on a piece of evidence, and because it is on that piece of evidence, that makes it more likely that a crime was committed. Now, how DNA evidence works is that there is a known standard, and whether that known standard is from an alleged victim or a defendant, it is taken with a chain of custody from that individual. It's taken by a large Q-tip in the mouth. They call it a buccal swab. They rub it in the cheek for 10 seconds, and then they stick it in a tube or a bag, and they send it off to the lab. Sometimes, but more rarely, it's taken from blood. So the DNA lab will extract and analyze that known standard, and what they're looking for is they're looking for the specific locations on the DNA. They're called markers. They used to do, I think, 8 markers, then it was 16, and then it was 24, and now I think they're up to 32 markers. But they look at each of these markers or locations, these specific locations on the DNA, and they come up with 2 numbers, 10, 5, 6, 12, whatever they may be. And so with a known standard, they've identified all markers. They've identified the 2 numbers at each marker. And then they'll separately analyze the piece of evidence, whether it be a swab taken from a firearm, a swab taken from a sexual assault kit, and they'll analyze that, and they'll do the same thing. They'll look at those 32 markers, and you'll get a result there. And often when you're talking about swabs from a sexual assault, it's expected that you're going to get a mixture of 2 individuals, right? If you have a foreign individual, that would show that a foreign person's DNA was there, but you always expect to get the DNA from the individual whose body it is. But then they compare the known standard to the DNA extracted from the evidence, and from there, they're trying to say whether or not the markers match, and from there they try to make a statistical comparison, assuming it's all of evidentiary value and showing that there was a crime committed. So how is DNA obtained? Well, the items of evidence are often obtained from a crime scene, or by consent. And so they collect these pieces of evidence, whether it be a firearm, whether it be touch DNA from a door handle, semen DNA from vaginal swabs, spit DNA from a soda can left at the scene. And they collect them. They're supposed to seal them separately in bags. The crime lab folks then analyze them. Now, as far as the standard from either the alleged victim or the accused, defendant, suspect, those are commonly obtained by either consent or by search warrant or search authorization. I do want to take a moment and talk about something that's called DNA based on probable cause to arrest for a felony. That is different than DNA that can be used in a current case. When an arrest is made based on probable cause, the authorities will often take that buccal swab from your mouth, and the purpose of taking that is that it will eventually be put in to CODIS. CODIS is a database, almost like a fingerprint database, of arrestees that can be used in other cases to make comparison to unknown DNA extracted in other cases. But for getting DNA commonly for a specific case, they're either going to ask for consent or they're going to go get a search warrant. Now, if you are a suspect in a crime and they ask for your consent to give DNA, do not give it. Just like everything else, never consent, never waive your rights, always invoke your rights. And if anyone is asking for your permission to search anything or seize anything, your answer is no. But if you have consented to DNA and it hasn't been tested yet, you still can probably revoke that consent. And the way you need to revoke consent is you need to revoke consent in writing, delivered to the agency or person that you gave consent to. And the example of that would be writing out on a piece of paper that's signed and dated, I hereby revoke consent given for my DNA sample taken on whatever date. Sign it, date it, and go deliver it to the agency or the investigator who got consent from you in the first place. Again, my name is Patrick Korody. I'm a military law and criminal defense attorney in Jacksonville, Florida. If you have a case where there's DNA evidence, you need an experienced attorney that understands DNA and knows how to fight it. There are ways to fight DNA. Call me 904-383-7261.